right, good afternoon. Okay, good afternoon, everyone. Thanks for joining us, and we'll all be very open and patient to the fact that folks will be trickling in. I want to start our time together by just saying we are being recorded, so we're all on notice there. But truly, I'd like to begin our time together making some thanks. First to the Rappaport Center and the amazing Lissy and Abby for their tireless work here. And then to our panel, who will have an opportunity to meet in just a second, for giving so generously of their time. And I wanted to start by saying how excited I am, and on behalf of the community, Boston College Law School community, how excited we are to hear from you. For me personally, I'm a family law professor. I work in the clinics with our social service advocacy program, and for the last 2 years, I've been running a family justice litigation clinic. So this topic is really near and dear to my heart, whether it's the fact and something we touch daily. So whether it's us negotiating parenting plans between our clients and their former abusers, or watching our clients anguish when they're ordered into parenting classes for high conflict parenting with their former abusers, or whether it's in the family regulation system when our clients are accused of neglect for failure to protect their children from witnessing the violence that victimized them. Not the children, then the parent. Or where kin are asked to make apology for restraining orders where they might have been issued against them, which would make some sense, but also where they sought restraining orders in their application for placement, or to make apology for the fact that they were unaware of or didn't mitigate the domestic violence that was going on in a kin's household that was maybe underlying removal of a child and their current petition for kinship. So all of that experience, though, I will say also maps onto my prior experience as a public defender, where I saw the criminal legal system doing a pretty sloppy job of understanding the various motivations, dynamics, and needs that led to accusations of domestic violence and informed state response to it. So I have really complicated feelings and reactions to everything that's here. But it strikes me that what I notice is that the court, the states, the laws seem to either fall on a binary where they're either ignoring or distorting domestic violence and interpersonal violence, or where they're weaponizing it against the very families and communities who are so burdened by that violence. And so I'm really excited to hear from the panel today, who will no doubt speak with way more confidence and nuance and detail on these important subjects. So I'm going to turn it over to our esteemed moderator, attorney Sue Finegan. And I have the pleasure of being able to introduce her to all of you, and then she in turn will introduce the rest of our panel. So Sue is currently a partner at Mintz, where she's a member of the litigation section and the chair of the Pro Bono committee. When she was sort of in your seat, maybe literally, was it this building? It was she at one point was literally in your seat, graduating from Boston College Law School and going on first to clerk for the Honorable Andrew Caffrey at the U.S. District Court of Massachusetts, and then the Honorable Frances O'Connor at the Massachusetts Supreme Judicial Court. She then had continues to have an illustrious appellate practice and complex litigation practice, but had a tenure, probably critical to some of the work and themes here today, as the legal director of the Victims' Rights Law Center, where she oversaw statewide civil legal services to sexual assault survivors. That no doubt informed her engineering of an important restraining order law here in Massachusetts for survivors of sexual assault. And as I said, now is operating as the chair of the Pro Bono committee, where she oversees the sort of distribution and supervision and handling of over 300 cases annually, pro bono cases. She's no doubt so well situated to take on that important work by her important leadership roles as a board of trustee at Dartmouth College and prior leadership role on the Access to Justice Commission. So we're so lucky to have her here with us, ushering us through this conversation. Thank you very much. Thank you.
Well, it's great to be here. I did indeed have my 1L classes all in this room, so it's really great to be back. It's always great to be back at BC Law and to meet all of you. And I'm really excited to be moderating this really important panel today. I'd like to go back to the title of the panel, though. The title of the panel is Past, Present, Pending, and Potential. And as about domestic violence, and as I thought about that, much of our discussion today is going to be about the second, third, and fourth, but not much about the past. So I thought I'd spend a few minutes in my brief introduction to talk a little bit about the past, which will set the table for this discussion. So it's interesting, I pulled up a paper I wrote maybe 10 years ago and refreshed my memory. And a couple of the things that I learned was that 150 years ago, the Massachusetts Supreme Judicial Court issued a ruling that basically found that beating or striking one's wife violently is not included as part of the marriage contract, which kind of makes sense now, but at the time I think it was somewhat groundbreaking. Unfortunately, they didn't move forward and provide any protections for the person being abused, but they at least provided that part. So let's fast forward. I'm not going to go through the entire history. I'm going to fast forward a bit to the 1970s, when in 1978 the abuse prevention order, the original restraining order, protective order, came into place. That was 100 years later. And that law was really critical because it created a civil remedy that allowed survivors of domestic violence to obtain a protective order from their abuser. And it also is very unique, and it's probably one of the only laws, even currently today, that provides for this unique criminal enforcement mechanism, such that if you violate this civil order, you then could get, go through the defendant could be criminally prosecuted. So I think the interesting thing about this is not that it passed, although that is interesting, but just how it got passed. And so, I say this because there are many students in the room who sometimes probably feel like, what can I do as a young lawyer? I don't know what I'm doing. I can't really make a difference. And so I thought it was unique about this is that there was a group of women who had just graduated from Suffolk Law School, and about 2 to 3 years after they graduated, having spent a lot of time working with survivors of domestic violence, and working on family law issues, would get together in one of their apartments every week, and they would talk about ways that they could try to change the law and what they could do for their clients. Because with their clients, they were feeling like their clients were really scared to move forward with a divorce and move forward with family law protection because they were continuously being abused by their abuser. And so it's kind of the thing that's so astounding, not only because they were 3 years out of law school, but they had no legislative drafting experience either. And they would get together every week and they came up with what is now 209A. And they kind of did it as an academic exercise, and their mission was to try to create some breathing room for their clients so that they could get away from their abuser and be able to then move forward, make some decisions without having to have that specter. So it also was interesting too because there's no blueprint for it. This was the first in the country. And so they were just kind of making it up, which is really interesting. And they figured it would just sit on a shelf somewhere and collect dust. But 2 of them, who were the drafters, went down to a conference in Texas. And they just happened to be sitting next to a state senator and her head aide and talked to her about that. And when they returned back to Boston, that senator, Senator Pollard, filed the legislation, and it ended up passing the next year. So I think that's kind of an amazing story of the power of being a lawyer and the power of being an advocate and having the client experience that all of our panelists have, and then turning that into action. And you could help your individual clients, but you might be able to make a huge difference by having that understanding of what clients. So with that backdrop as the past part, let's move to the other 3 parts, the present, pending, and potential. And I have the privilege of introducing my fellow panelists. Rachel Biscardi is the managing attorney for the Family Law Unit at Northeast Legal Aid, where she specializes in cases involving family law and domestic violence. And Rachel co-supervised the Family Law Advocacy Clinic at Suffolk University Law School and also taught family law at Northeastern and New England School of Laws. And I could go on, but I won't. Like, she's done a million things in terms of like policy and strategy, and we've worked together a lot, and it's been a real privilege to work with you. Emily Dillan is a recent graduate of UMass Law School, where she graduated summa cum laude, and she's serving currently as a law clerk to the Norfolk and Camden divisions of the Probate Appeal Court. So she's a little bit snobby in what you can say today. So I just wanted to say that so that you're not going to get in trouble from your court. But more importantly, you were a 2021 Rappaport Fellow, where you wrote a really amazing paper that I read last night. It was really well done, and it was all about domestic violence and restorative justice. So we're going to hear from Emily first, and she's going to tell her own personal story and what drew her to law school. And last, we're going to hear from Hema Sarang-Sieminski, and she is the Deputy Director of Jane Doe, Inc. And Jane Doe, Inc., for those of you who don't know what that is the Massachusetts Coalition Against Sexual Assault and Domestic Violence. And there, she has directed strategic, legislative, and systems change efforts and led efforts to shift the field's reliance on criminal, legal, and other punitive systems. And you've been doing this work for a long time. We've intersected a lot over the years, and we're thrilled to have you on the panel. And I'm going to turn it over to each of you to give some opening remarks, and I'll turn it over to Emily first, and then Rachel will go next, and then Hema will go next.
Good afternoon, everybody. So Sue graciously gave a little bit about my background, but what she didn't tell you is that I'm a survivor of domestic violence. I spent most of my early to mid-20s in a cohabiting abusive relationship, and I know that I'm not alone. In this state, 1 in 3 female-identifying individuals and about 1 in 5 male-identifying individuals will also be survivors of domestic violence. So look around you, it's more common than you think. When I left my abusive relationship, all I really wanted was justice. And the reality is I never reported. That's a common experience with survivors, and the reason for it was just because I was afraid of the consequences. I was afraid of the consequences that would be inflicted on me, right, socially, societally. I was afraid of the consequences that would be inflicted on my abuser, criminally, right, socially as well. There's a stigma with that. So after leaving, I decided that the best way for me to get justice was to rebuild my life and do a damn good job of it. I started working as a tax preparer, of all things, and from there I decided that I was going to get my associates in business. From there I decided I was going to get my bachelor's in business. And at that point I was looking at becoming a CPA. Now, I took one look at the schooling and the money involved and said, well girl, you've always wanted to be a lawyer. You should just do that instead if you're going to put that much investment into being a CPA. You don't really want to do this. So that's what I did. I thought I was going to become a tax attorney. That was my plan. I started writing personal statements for law school acceptance and went, this doesn't feel right. And the more I thought about it, the more I realized that I could get justice through other people. And by that I mean I could take what happened to me and use it to turn it into something good for somebody else. In the beginning, that started as just, I want survivor justice. But as you'll come to hear, the more I learn, the more I realize that that also sort of extends to abusers, which is a little controversial, right? But hurt people hurt people. And I think my experiences doing this so young made me realize that had there been more, let's say, systems in place that could have helped my abuser, perhaps that would have helped us sort of get out of the dynamic that we found ourselves in. Naturally, every experience is different. I'm not saying that that's true across the board, but for me, that was true. So I ended up getting into UMass. I decided to go there. I had heard about the Rappaport Fellowship while I was applying to schools, while I was researching them, and I sort of stashed it away in my mental filing cabinet. I knew it was something that I wanted to apply for. I decided to apply my first year, and I was selected. And I was placed with the Office of State Rep Natalie Higgins, where I worked on domestic and sexual violence legislation, including a couple of national initiatives like the Phoenix Act and the Sexual Assault Survivors Bill of Rights. That lit a passion in me, big time. And while I was with Rep Higgins' office, I happened to hear of this concept called restorative justice. And I thought, wow, those are two words that both go together and don't go together at the same time, right? How do we reconcile this? So I started to do some research. From there, Lissy advised us that we had the opportunity to apply for grant funding, where we could research a topic related to our fellowship and kind of go crazy writing this academic paper about it. I knew I wanted to do it, but I didn't know what the contours of that looked like. So Rachel, who was my mentor, and Hema, who I had met through my work at Rep Higgins' office, both graciously spoke to me about restorative justice and sort of served as the landing board for which I bounced ideas off of. Through Hema, I learned that the Chapter 276B of our laws prohibits restorative justice proceedings in a diversionary context in domestic violence cases. The actual language is for assault and battery against a family or household member. And I thought, wow, that seems really counterproductive, because to me, that was something that would make me report, right? Knowing that there was this alternative to the criminal justice system for myself, for my own relationship, was something that may have made me think about maybe having the guts to go out and say what happened to me. So I started doing more research. I was selected for the research grant, and at that time, Senator Jamie Eldridge was gracious enough to meet with me and sort of share what he knew about restorative justice. Now, Senator Eldridge was the reason that Chapter 276B had passed. He had been trying to pass the legislation from 2011, and he had introduced it in every single legislative session through 2018. Interestingly enough, the carve-out for family violence situations and intimate partner violence situations didn't come about until 2015, when a local DA's office requested it to be added to the bill. The reason being was actually because they were worried about siblings getting into altercations. It had nothing to do with an intimate partner violence context, which I thought was really interesting. So at that point, that's when I dove all in. I said, okay, how can we make restorative justice in a diversionary context happen for intimate partner violence survivors? The grant was amazing. I met with so many folks. I got to meet with 2 restorative justice facilitators in our state, one of whom introduced me to Patricia McLean, who is a Maine domestic violence advocate and also the ex-wife of Don McLean, singer of American Pie, and a domestic abuser, no less. Terrible, I know. I also got to meet with a California-based attorney whose jurisdiction was using diversionary restorative justice, and it was going well, so I got to speak to her about that. And I also met with various professors at UMass, BC, and BU, all of whom shared with me what they knew about intimate partner violence and restorative justice more broadly. So that's sort of how I got to be here. Restorative justice is what I'm here to talk to you about today, and I'm excited to do so. Thanks for having me.
Thank you. Rachel?
Hi, I'm Rachel Biscardi, and I'm the managing attorney at Northeast Legal Aid's Family Law Unit. I wanted to tell you a little bit about my background and history so you know where I'm coming from, and also you can feel free to reach out to me with any questions anytime, because mine is sort of an odd story. Since I was in 6th grade, I was one of those weird people who knew I wanted to be a lawyer. For those of you a little older, you may remember LA Law. I was going to be a DV prosecutor. That's all I ever wanted to do. And the irony is I actually was hired to be a prosecutor, and within maybe a minute and a half, I realized it was the worst mistake I had ever made. That it was not at all what I wanted to do. And at that moment, I was like, where do I go from here? What do I do? I mean, I was like, this is really confusing to me. But I had a bunch of internships in law school, and this is where I plug, doing things not necessarily that you know or in your career path, but are of interest to you. I had wound up working at Northeast Legal Aid, where I'm at now, as a maternity leave replacement, and I had loved it. So I kind of had a feeling that maybe legal aid was where I belonged. And I clerked thereafter, also at the Probate and Family Court, and I wound up being really interested by the area of law. And then I met with this woman named Lissy Medvedow for a position at the Women's Bar Foundation. And we talked about Chinese food for about an hour, and then she hired me. And, the thing is, you never know where you'll wind up. So I started working with Lissy, and she said to me, there's this task force growing about alimony. And, I know it's not necessarily what you do, but are you interested in it? And I thought, no one ever thought I'd get into legal aid to discuss alimony. That's a rich person's issue. Boy, was I wrong. I agreed to do it, and it was the most wonderful thing I ever did. I wound up working on the legislation that became law in 2012, the alimony reform law, and I learned the intersection of domestic violence in all areas of law and how really money intersects with power and control. And so I had the opportunity to participate in a bunch of other task force just by volunteering. And this is where I tell you, much like Sue's story about the recent law school grads, volunteer. You never know where it's going to take you. You never know the opportunities it's going to provide you. And I just volunteered for everything. And I wound up I love family law. I love working with domestic violence clients. I feel like it's it's a really good way at the end of the day to go home and feel like you've done, if I've done nothing else, I've given someone a little bit more of a voice that they've had before. And I want to share with you, you're going to have bad days in court. In fact, you may have more bad days than you have good days. But at the end of the day, to stand next to someone and be a little bit of a communicator, even like, you know, this is where the restroom is an invaluable service. So I implore you all to really take opportunities that you might not otherwise do, things that you wouldn't necessarily do, because they wind up really benefiting you. And this is what sort of leads me here today to talk about what the present is in the probate and family court and the district court, and what the role is of survivors. I'm worried I'm going to be a little bit of a Debbie Downer, so I apologize, because, you know, some of it is not so great what's going on, and I feel like since the restraining order law passed, we've hit a little bit of a backslide of courts and judges and advocates that have become a little inured to domestic violence and sort of get this look on their face when we walk into the courthouse of, oh no, here's another legal aid attorney. But two last things. First of all, I wound up in my job. I left the Women's Bar Foundation, and I wound up working in private practice for 2 years. And again, I wanted to just try it. But at that time, I was asked to be a consultant at Northeast Legal Aid because they had a newer supervisor. And I was a consultant there, and I loved it. And then when the supervisor left, they said, do you want this job? And I was like, are you kidding me? Absolutely. But all of this volunteerism and sort of really gave me a sense. And now I joke that I'm in the greatest job in the universe. I work with new attorneys. I get to help teach them and work with them and mold them and help them do best practices I've taught. Just so you know, it is a joy talking to all of you. Please never hesitate to reach out. It reminds me of why I did this. It reminds all of us of why we do this. And I am so excited to hear about restorative justice specifically, because I went into my career by saying, restorative justice is not a solution. It's not really something that I think it's a crime. If domestic violence happens, it should be treated like a crime and punished as such. Well, I've now been doing this work for over 20 years, and I can tell you that our system isn't working, at least from my perception. And I would really like to find alternatives. So again, this whole you think you know everything turns out to be not so much true. And I'm really looking forward to learning other avenues that I can point my clients to when they really want, a different path than maybe the law can afford them right now.
Hema? Thank you, Rachel.
Thank you so much. So when I was thinking about this story that I wanted to share about my path on how I got here, just to start with, my name is Hema Sarang-Sieminski, and I'm the Deputy Director of Jane Doe Inc., the state coalition against sexual assault and domestic violence. And I think I have always been oriented towards coalition work. There is something about the messiness of coalition work. I thought again about this essay that was written probably in the mid-'80s, Bernice Johnson Reagan, on coalition politics, and really talking about this is messy stuff because our work is messy. Messy in that so many of our identities, our desires for justice, our desires to see safety, to see wholeness for all of our communities moving forward, it requires a coalition approach. And I never would have known this prior to becoming an attorney, but I was very much drawn to spaces. I really came into my interest in legal work through the Women's Law Project in Philadelphia as an undergrad intern, and was introduced to an approach to law. Their focus was primarily on impact litigation that was deeply intersectional. So they were taking on at any given moment issues of reproductive justice, issues of intersections of access to contraceptive care for young women of color. They were really looking deeply at the law, and to me this was the most eye-opening piece through so many different angles and approaches. And that was really inspiring to me. And they let this 19-year-old kind of put on a panel on, reproductive access for queer folks, for young folks of color, and it was really just kind of one of those heartening moments to remember the gifts that we receive from our mentors who let us run with our ideas and projects, and really encourage you all to take heart and do that kind of running. My work really, the trajectory of when I really coalesced into wanting to do legal work, it came from an experience after graduation, undergrad, of working for a domestic violence law project. And at the time, I wasn't entirely sure I was interested in family law or anything like that, but I knew I wanted to do work with survivors, and that was really clear to me. On that hotline, the turning point for me was I was hearing from survivors who were talking as much about their experiences of deep pain and harm and betrayal from people who they loved, who caused them harm, but equally, if not more so, about the pain and harm of systems that they were interacting with. And that issue, to me, that brought home this need for me to be really at the intersection of working to dismantle systemic violence, as much as I was focused on supporting survivors who were dealing with interpersonal violence, and the connection between that kind of systemic or state violence and interpersonal violence really was brought home through those stories of those survivors. They were talking about, I reported my harm and now DCF is after me and my kids are going to get taken away, or I'm a survivor who's an immigrant and I'm now facing removal. And so that, for my takeaway from that was then to go to Northeastern, which is where everything I was surrounded with in New York somehow was going. So in that Northeastern public interest crew of the early 2000s, and I really decided to do immigrant justice work from the perspective of working with survivors who are both simultaneously in this space of victim, survivor, as well as defendant, really facing Department of Homeland Security as their prosecutor. And that piece, it's a really helpful thread here to think through, brought home to me the importance of recognizing and looking at survivors as complex, and because we are, I also identify as a survivor, and resisting those narratives of who is deserving of support, what a survivor looks like. No survivors, there are no two survivors who look the same, and really recognizing the fact that many survivors are facing these simultaneous pulls of both existing in places where they are criminalized while also deeply needing support and healing from the harm they're experiencing. So that has launched me into the trajectory and the direction that I bring to policy work at Jane Doe Inc. And really trying to center and uplift the needs of all survivors, from access to safety and justice to economic security to racial justice. And we'll talk more about that as we move into some of the future directions for this work. But it's a bit of how I got to be where I am today.
Thank you. And thank you all for sharing your stories and what brought you to this work. It's really important to kind of ground the work and your experiences. Guys, I'd like to kind of go back to something you all touched upon, and that the system is not working. I think that's your quote. And let's particularly think about the court system for now. We are at a law school, so I think that's probably important to do that. And I think, Hema, you mentioned the pain and harm that systems that they were interacting with. Could you sort of touch upon that? What's the difference between the law that's written and the practice of what people experience as they go through the court system? I think the probate and court and the district court. I know you probably can't speak to this because you're at one of those court systems, but perhaps Rachel and Hema can answer this question.
First? Sure. I think that some of the common misperceptions come from a very good intentions. So let's start with the definition of domestic violence that those of us in the community use, which is, there's many words, but I think we all think of it as coercive, controlling behavior. It is basically behavior designed to make someone do something that you want them to do. And a pattern of that behavior which exhibits control over another. You may notice that nowhere in that description did I talk about any kind of physical violence. However, our laws, our basic restraining order statute, is a physical abuse statute. It requires there be physical abuse, sexual abuse, or there be a threat that causes fear of imminent serious bodily harm. So all of those are physical in nature, but many of the survivors we see that come in to talk to us, first of all, they may not necessarily feel comfortable talking about the physical violence. In fact, from my perspective, most survivors I speak to don't start off with the physical violence because frequently that's not the part that may hurt them as much. It may be what they were called, or it may have been, that they took their immigration paperwork. So, but the courts are not designed to look at those gray areas. So in district court, for example, there is this physical abuse statute, so you can't go in and get a restraining order, even if you're very much afraid, unless you've suffered that kind of physical abuse. So that's the first piece of it. The second piece is when you go to probate and family court, I think one of the perceptions my clients have, and I probably had when I started, is that the judge is going to say, sir, ma'am, whichever one was the survivor, you are a wonderful human being. I don't know how you put up with this for so long. You're going to get everything you want. You, ma'am, sir, are a terrible human being, and you're going to now lose everything that you've wanted as, because that's justice. That's not what the probate and family court is designed to do. If you think you're going to leave feeling validated based on your experience, that's not going to happen. And I think it's a hard sell for survivors who finally have the courage to come forward and tell their stories, let alone tell their stories in court, and then feel like they're not being heard because it doesn't seem to matter. And I think, Hema can talk more about the systems intersection of this, but the probate and family court was designed to look at best interests of the child. So unless they can make the nexus between the domestic violence that occurred and how that impacts the child, it's very hard for a survivor to be able to succeed in convincing the court of what it is that would be best for the children. And survivors, I often say, come in all shapes and sizes, and one of the perceptions that I think society has about victims is they're all going to come in, they're going to be soft-spoken and quiet, they're going to have one single tear that runs down their cheek, and they're never going to say anything that makes anyone else mad because they're subdued. And maybe that survivor exists, but I've never met that survivor. And so I think there's this perception that, survivors should look a certain way and act a certain way, and we're human beings. We just don't. And until I think there's a way that the law can recognize the grays, especially in the way people present in court, I think we're going to have problems with there being any kind of justice. And it breaks my heart to start, when I teach family law in class, I put a life lesson on the board each class, and my first life lesson is, you don't go to the probate court for justice. You have to find that. Whatever it is you need as a survivor, you need to find that within yourself and your community. And so I think if that could be, you're not going to get the judge who validates everything that you've been through. I mean, maybe there are circumstances where you will, but they're few and far between. And I want to always make sure, and please do if you ever represent domestic violence survivors, that there are secondary supports for them other than just law. Because we can only do one small piece of the whole process. And that's kind of what I think is a common, the difference of what I see law and practice. And I can talk about specific statutes in a little bit, but I wanted to turn it over to you to talk about.
Just to underscore that too, it can be somewhat frustrating. You're going into court, you're thinking, even as a lawyer, it can be frustrating because you can only do so much. So it's not just the survivor, but if you're representing someone and going into court, you have to then explain to your client that they might not even get the restraining order. But then they're certainly not necessarily going to, that judge isn't going to help them with a loss of housing, or the fact that their abuser stole their credit cards and they have no money, and all of those they might lose access to their children. So it can be a bit, it can be, as a lawyer even, be frustrating to interact with the system. Sorry, Hema, you're on.
No, yeah, absolutely. I think that's a really helpful context to set around the limitations of some of these systems in terms of what they can offer to survivors. And I sit in the coalition space thinking about the history of how coalitions even came into being. This was, and many would argue still is, a movement, right? It is a movement towards social justice for survivors. And if we think about the origins of how we got some of this, as Sue was talking about, like how do laws come into being in the first place? I mean, it is through agitation, it is through organizing, and I really do believe that the deepest and best root of policy solutions really comes from those who are most impacted, and it needs to come up from those direct lived experiences. And we'll talk a little bit later about some new policy initiatives that are really very much being driven by the survivor advocates who are pushing for these. But I think on the systems question, that distance between the law as it is written and then how it's applied, yes, absolutely, 100% echoing what Rachel mentioned about that can't be the only source. That is not a place for healing. And we also have power as various stakeholders in these systems to push, right? We know, I don't know if folks are familiar with Denim Day and the origins of Denim Day, of a judge who had essentially shamed a survivor and denied her accountability or justice after a sexual assault because of the tightness of her jeans, right? That was sort of the I'm summarizing briefly, but that shifted, and in many courts, hopefully across this country and certainly in Massachusetts, you wouldn't see those kinds of there's change that has been demanded around how do we create trauma-informed spaces for survivors? How can we demand that or recognize the fact that if a survivor is not coming back to court because of how they were treated, that's a problem. That's a public safety problem, right? And so we can begin to address some of those through these coalition efforts. And when I talk about coalition efforts, it's really everyone from the legal services lawyers to survivors to domestic violence and sexual assault advocates, sorry, my hands, to our assistance partners, to our legislators, right? There are well-meaning and proactive allies in so many different arenas, and the power that we can harness by working in collaboration together. Right now, JDI is doing a courts listening project where we're listening to the experiences of survivors and advocates in Massachusetts courts. What comes out of that is going to require a coalition effort to say, what do we do with this information? How do we want to push in meaningful ways more accountability, receptivity, trauma-informed practices in some of these spaces that we rely on for protection?
Thanks. So before we talk about the gaps and how coalitions like Jane Doe is kind of moving forward with new legislation, can we talk a little bit about how, a little more positively maybe, about maybe a few things that you might have seen over time that have changed for survivors, whether it's the court system or in advocacy with the court or advocacy with the administrative process?
I'm happy to start if you.
Yeah.
The first thing I've seen, and I've been doing this for 20-something years, is an increasingly, I frequently say two things. For immigration purposes, by and large, the family law, the probate and family court is not really interested in your immigration status. They don't hold it against you. They don't, unless there's a threat to take the child. So I think that is a movement in a very positive direction, that most judges understand that that is not as pertinent to the case as other factors may be, and I've seen that change. That doesn't mean we're perfect, but it's getting better. The other thing is for queer families, I feel like Massachusetts has really been progressive in terms of its laws and also its practice in the probate and family court of really understanding that families are formed in many different ways, and so it feels like that is a positive direction. I think most courts and judges do understand, even if the laws are based primarily on physical abuse, that domestic violence, domestic abuse is also emotional as well, also covers so many different areas. So when I do share stories of controlling behavior, such as one party not letting the other party out of the house, they do understand those kind of things. And I think that's really been progressive. And the other thing I've seen is the amount of good new attorneys can do. We have this 303, SJC Rule 303, that allows people to be certified to go in and work. And I think having those attorneys come in is an incredible way of allowing people more representation. Law firms take on pro bono cases in greater number than I think that I've seen when I first started. And the more people that we can represent until we have free civil legal aid for all, I think is a wonderful development.
Emily, I don't know if you feel comfortable speaking, but maybe you could speak from your research that you did and in terms of from your own personal experience, and then some of the things that maybe you nationally you've seen through research. I know you did a lot of outreach and spoke to a lot of people. I don't want you to get in trouble with your court, but maybe you can talk from your personal experience and your research.
Certainly. I will echo Rachel and say that things have become a little bit more progressive, right? There's no longer this sort of what Hema had touched on, where you expect the domestic violence survivor to be a white, middle-class, wealthy, straight woman, right? That isn't necessarily the case, right? We know that survivors can be men. Survivors can be queer folks. Survivors can come in any flavor under the sun. And there's really been a push nationally towards this legislation that kind of helps recognize that and also provides, sort of expands on the rights that are already given. Like, I'll take the Sexual Assault Survivors Bill of Rights, right? Like, the goal of that is to just improve access to justice when those survivors enter the courtroom, right? They're given certain information. They're given somebody that they can talk to. They have a victim witness advocate, right? You get all of these resources under that bill. Of course, there's also like the crime victims' Bill of Rights. It's very, very similar. But when you get into these crimes that are domestic and sexual violence in nature, there's a whole different layer of trauma that goes with that, right? This is somebody you know. This is somebody that you probably love, as you had said. This is somebody that, worse yet, you believe loves you, and look at how they are treating you, right? That really takes a toll. So any way that we can sort of expand on our perceptions of what we expect abuse to look like is really important. And I think over time, we're starting to see that happen.
Thank you.
Yeah, I echo most of what you all have said already, but I guess the one place of hope for me is our vantage point is primarily with systems, stakeholders, and contacts. And at that level, when we're talking about how we can acknowledge that the systems themselves have a lot of work to do, right? At the level of those who are invested in and charged with addressing the needs of survivors, so when whether we're talking about the domestic violence and sexual assault liaisons at DCF, or with the DAs, or the police, those conversations exhibit to me a level of understanding of the issues that I'm honestly grateful for. So at that level, sure, do we talk about implementation issues, etc.? So much. But it is, to me, a positive sign to recognize that the right folks are holding those spaces with the right ideas around how to best bring about trauma-informed, survivor-centered practices.
Let's talk a little bit about some of the gaps and some of the things that, some of the legislative pieces of legislation that advocates like Jane Doe is working on. Because I think that would be interesting to see like what's happening right now in policy in this area. I had a chance to look at your website. I looked at a lot of the things. I was actually struck by the breadth of what you're supporting. So I think it would be interesting to share with the audience what you're working on.
Yeah, sure. So we take a very intentionally intersectional approach to our policy agenda, and we really look at, given that we've talked about in a number of ways that there is no one-size-fits-all set of relief for survivors, we look at a policy agenda that is inclusive of racial equity, of access to safety and justice, economic security, human dignity, and prevention and education. So those are sort of our pillars of our policy framework. A couple of key priorities in the access to safety and justice, very relevant to today's conversation, have been survivor-led and driven. They are protections related to coercive control and incorporating a definition of coercive control into our 209A or abuse prevention statute. This bill is also paired with something we're one of 2 states that does not address this kind of harm, which is the non-consensual sharing of explicit images or image-based assault. Some folks commonly refer to it as revenge porn. We at JDI like to call it image-based sexual assault. Those are gaps, so we are, like I said, 2 states that don't have, one of 2 states that don't have protections, along with South Carolina. And the rationale for highlighting these 2 particular areas, it really came from survivor stories. And I think that we are excited that this has passed in the House and is now sitting with the Senate. The stories that came from survivors around these gaps were extraordinarily powerful, really laying out there was nothing for me in this particular situation. I was told by a judge that, and essentially, until there is physical harm or an imminent threat of physical harm, I can't get protection. Or in the image-based sexual assault context, sure, this is incredibly harmful, and we know from the data that those who have experienced this kind of distribution of sexually explicit images, are at such higher risk of further sexual harm, and yet there was no protection in Massachusetts. So that's something that's again, these bills are backed by survivors across the Commonwealth. Another companion bill is protections around abusive litigation. It's when the courts become a site of furthering the abuse. So what happens when people who cause harm use the court system, use litigation as a way of controlling a survivor's time, money, safety, bringing them back into court over and over and over again, which is, I know, no stranger to. I look at Rachel's face right now and see the recognition of those types of tactics. So those are a couple in the access to safety and justice that are particularly relevant to this conversation. And then we're also doing things like supporting a 5-year pause on the building of new prisons and jails in Massachusetts. Because, we navigate questions all the time of, why is this a survivor issue? Why is JDI taking this on? And the reality is that when we're talking about building a new women's prison at a price tag of $50+ million, there is various statistics, but really place 70 to 90% of women in prison have experienced domestic violence or sexual assault. And so we're talking about imprisoning survivors. What else is possible, and what could community-based organizations do with those kinds of resources to support reentry, to support resourcing communities in different ways. So it's a real breadth of work we do. I don't want to, there's so many on our agenda, and I don't want to leave time for others to chat, but always glad to talk about the breadth of our policy priorities and the why behind it.
That's great. Rachel, can you comment upon a couple of those things, the course of control, that use of litigation? I know I just finished up a case where I was representing a client who I had gotten a 25-year protective order for, and she had been raped repeatedly when she was 12 years old at a camp, at a summer camp. And the defendant kept bringing her back into court. Motions for reconsideration, filed an appeal, filed it like with the SJC, filed something with the appeals court. And if she hadn't been represented, I don't know what would have happened. She would never have even gotten probably the 25-year protective order, but I think she would have just given up because she basically had to go into hiding and had to hide her address and move many times to get away from him. And so that's, I think, a good example of this abuse of litigation, using the court system to continue to see someone, to continue to control them, and using the court process to do that.
I can talk about my experience yesterday, as recently as that. I was in court on a restraining order for a client, and I was there supervising our newest attorney on her restraining order that she was getting for a client. I'll talk about mine because it had a little bit of a happier result. She had a permanent restraining order issued, but it took her year after year to get that. She had to face him 4 times in court. Each time she had to relitigate the grounds of the restraining order. What made this especially horrific is she was a victim of human trafficking. So her story, she was so young, it was especially hard. And the person I supervised went in on a restraining order and got the restraining order extended, and the client was so happy. She was crying and she got the order and she left, and I was waiting for my client's restraining order to be typed up. And I saw the defendant in her case walk right into the registry's office and file a motion for reconsideration on the restraining order. Nothing had changed. It'd be 5 minutes since he had gotten the order, but he did that. And because we want to provide access to the ability to litigate if appropriate, there's nothing curtailing that kind of behavior. And what we're seeing, especially with restraining orders, is that defendants are relitigating them over and over again as a means of controlling the victim and continued contact. And we see this also in probate court. In another case, we were in the district court, I think, 8 times in like 5 months on various motions that the opposing party had filed. Just same motion, just worded differently each time. And in probate court, that happens all the time because the standard is a change in circumstance. And that's, even if the judge ultimately rules the correct way, it still means the victim has to go to court. And I have to say, as someone who wants people to have the ability to file motions and wants to make sure that people can litigate if appropriate, how do you juxtapose that with a victim's right to be free of the person who's perpetrating the crime? And one of the things that we see the most is I frequently tell my clients, when we're in court, we're going to talk about safety. What the opposing party is going to talk about is everything else. Her mother, she's crazy, she's only after money, everything else but safety. And what happens is you watch the victim become increasingly, your client become increasingly demoralized, where even if she winds up getting what she wants, it's still, the experience is so difficult for her. And I wish I could come up with a way, and I'm hoping with coalition members I'll be able to really strike a balance between allowing people the ability to, exercise their civil remedies for relief, but also allowing a victim to be able to be free. I mean, this client who we represented yesterday has to come back to court in 10 days and relitigate it again. And even if she gets a favorable order, that doesn't mean he can't come back and file something else again. And when I was talking to my client about her permanent order, I used to be able to say, it's permanent, you won't have to come back. But now I see increasingly that the defendants in these cases are filing motions to vacate. And I think that there just needs to be some sort of solution about that and how to mix the two.
So we have about 5 to 10 minutes, and then we're going to open it up for 2 questions. And I want to spend time on restorative justice, and I'm going to have Emily go first on this. Can you tell us a little bit about doing your research? What are the pros and cons? Because it's somewhat controversial in the context of the court system, so it'd be great to talk about that. And then I'd love to get both of your thoughts on the concept.
Sure. So it probably helps to give a little bit of a definition as to what restorative justice is. And I'm going to speak very broadly because when you actually read a definition, it reads like gobbledygook at first. I read several and was like, what does this even mean? At its core, it's essentially a series or a variety of practices that facilitate a communication between a person who has experienced harm, whether that's crime, whether that's on the civil side, anything, and the person who has harmed them. Now, depending on the practice being utilized, you can also bring in other members. So you can have family, you can have friends, you can have community members, you can have other stakeholders who might be present, the police, etc. But at the end of the day, and again, I am very broadly generalizing, it is essentially a very cooperative, very intimate victim impact statement, right? Like you are sitting down and saying, you have harmed me in X, Y, and Z ways. This is how it has affected my life. What can we do to move forward? Now, some of these practices end in an agreement. So what you could do is say, you know, it's survivor driven. The survivor could say, you can never abuse me again. You can never talk to me again. You can never do whatever. If the parties have to stay together or want to stay together, you can put conditions in for that too, right? Like, you will never raise your voice at me again. You're going to get substance abuse counseling if that's in the picture, right? You are not going to talk to our children in that way ever again. So it's really customizable, and I think that that's one of the biggest pros. Now, going into the cons, and I'll start with the cons first. The biggest one is really that folks are worried that it implicates a defendant's Fifth Amendment rights. And by that, it's because it's a diversionary program, right? Under the law, 276B, you can go into this diversionary programming anytime after arraignment. What that means is that they're basically suspending prosecution, hinging it on how the restorative justice practice goes, and then they can resume prosecution again. So if you have an abuser that goes into this conference and starts telling the story, right? Well, now they've incriminated themselves. Now when they go up, if it happens to fail and they get prosecuted, now we can bring that into court. A lot of programs that are using it in a diversionary context require an admission of guilt to get around this right out of the gate, which is smart, right? Right out of the gate, you're accepting sort of accountability, which is what these programs are all about. So that is a con that you can sort of work around. But then there's other cons too, like it's coercive. It's coercive against the defendant, right, who's seeing basically a get out of jail free card, not to be flip. It's coercive against the survivor, right, who feels like, well, I love this person. I don't want to see them go to jail. I don't want to see them get fined. As Hema's referenced, this could affect my children, right? So now they suddenly want to go into it, whether or not they're ready for it, both parties. It's coercive if you're getting into like circle programming against family and friends. They might not approve of the relationship. They might not want to be there, but they go anyways because they feel as though they have to. So those are sort of some of the cons. You also have survivor re-traumatization, right? You can have an abuser that kind of can't handle what they're hearing, right? It's hard to hear the ways that we've hurt someone. It's really, really hard. It's even harder to apologize. I think we can all admit that, even outside of the context in which we're currently speaking. So it's not uncommon for an abuser to sort of fly off the panhandle, right? They react in rage. There's the risk of harm happening after the session, right? Coming back for retaliation. I'm trying to think. There's also the risk that the abuser could manipulate the process, the parties, the facilitators, because abusers by their nature tend to be very manipulative. It boils back to this topic of coercive control. But there's a lot of pros for it too. And for that, I think about a statement that the judge made during the Ahmaud Arbery case, which was, sentencing is not closure. And that's really what restorative justice boils down to. It gives a survivor an opportunity to tell their story, to be heard, right? Because in their relationships, whether that's family or an intimate partner, they usually aren't heard. They can say over and over again, you did this, it hurt me, and it's just brushed off. They continue in that cycle of abuse. But this forces them to sit down and listen, right? So that right there is a very powerful thing. As I mentioned, it's survivor-driven. For couples that may have to stay together or, for whatever reason, share children, maybe they live in a small community, it can serve as the end of one relationship, also known as the end of the abusive relationship, and start fresh for a new one, right? That relationship might never be the same after what's said during that conference, but now you've sort of cleaned the slate so that you can move forward. At least that's the hope. It's also cost effective. In California, it costs about $250 per session, and they're finding that the costs reduce the more that they do it. And it also reduces recidivism rates, about 9% overall, which is no small change, really. There's also a study based out of Minnesota where they found that out of all of the program participants, only 20% went on to reoffend. That sounds like a big number, but when you think about it, it's really not, because the average rate of recidivism in domestic violence crimes is 30 to 40%. So we're already finding that it's working. Do I think that it's the solution? No, I don't. I see that there's a lot of cons, there's a lot of potential ways that this can go awry, but I think it's a solution. And I don't necessarily know how we can tailor it to make it work here in Massachusetts, but I do know that there's a lot of other jurisdictions that are doing it, so it's not necessarily impossible. It's just going to take time and resource.
Hema?
Oh, I love this topic so much. I get so excited. Yeah, thank you so much for that, laying that out. And, you know, I'm always talking about restorative justice within the context of court systems and diversion processes. And, you know, there's so much rich material about the history of restorative practices generally. There's also restorative justice as opposed to transformative justice related work. I mean, the idea of this is sort of conflict has been resolved in communities in a number of different ways for forever. You know, when this question around how to apply some of these principles to sexual assault and domestic violence comes into question, I think for so long it's been sort of hands off. We can't do this. We can't treat these kinds of harms in this way, right? This isn't the same as someone, you know, stealing something from the grocery store, or, you know, I use restorative practices in my own family, like with our kids all the time. Like, these are the, yeah, like picking out movies. Yeah, like, I mean, there's circles around this sometimes. I mean, not to shade like by any means, but these are about how to be human with one another. And, you know, when I think about the story that Rachel, you just named, around that practice of you get a restraining order, you go down and you try to vacate it instantly. Who is holding that individual accountable for that kind of behavior, right? Who is their community? Who's in their life, apart from the survivor, who's in their life that is seeing that kind of behavior happen and staying silent around, are you kidding me? Like, who is that? And so to me, sitting in the coalition space, like we hear from programs, you know, survivors are asking about these restorative, even outside of the justice system pieces, they're asking about, you know, what can I do to restore my relationship with the abuser's community, like, or my own community who betrayed me, right? There are restorative practices that we can bring into being and talk about, the principles of restorative justice or transformative justice principles that we can bring into our work that can be profoundly meaningful and supportive of survivors, even as we move to potentially, you know, having some kinds of more formalized systems here. That those can be parallels. And there are going to be survivors who would never want to, of course, like you said, is it the be all and end all? No, for some survivors it may work. Others are still not going to want to have anything to do with these particular systems. But what can we offer to our communities? What can we offer to survivors to create processes where there is some level of accountability and being heard and understanding about the impact of domestic violence and sexual assault on all of us, right? Like that there's something so disconnected in that case, in the story that you just shared, Rachel, and of course talking about it being an ongoing pattern of somebody gets a restraining order, is found to have caused this kind of harm, and goes down to try to vacate it immediately, there is an opportunity there for, to me, it's really, what is the bystander intervention role there? What are our community responsibilities to begin to think about our collective role in intervening in these kinds of harms. So, I mean, we held a conference on the intersections of restorative justice and transformative justice and sexual assault and domestic violence, and so much to think about that came out of it. But most importantly to me is the thread of how do we begin to draw from restorative practices and these principles in our everyday work, right, in lawyering, in working with systems, all of it. So, thank you so much.
Anything to add before I open it up for questions?
Did you want to add something quickly?
Oh.
May I? Briefly?
You can go ahead.
One quick note, not all hope is lost. 276B doesn't forbid restorative justice practices when a crime has occurred. You can do it alongside prosecution. You just can't do it as part of a diversionary program. It's also being used in the state in civil cases. So it's not totally barred. I just wanted to throw that out there, just as a diversionary practice.
Very quickly, I feel about restorative justice the way I feel about a lot of things, including mediation for domestic violence survivors, which is a very controversial topic. I represent low-income clients. That's my client base. And I want them to have every choice that a rich person has. I want them to have access to everything and make those choices themselves. And so if there's another option I could give them that might meet their needs, it might not, I would like to give that to them because I don't know the answer. And I think one of the most powerful things an attorney can say is, I don't know.
Thank you. I'd like to open it up for questions. Go ahead. Hi, Mary.
Thank you. Hi, Sue. Hi, Hema. We're going to see if a student.
Yeah, of course.
She
Raise your hand first.
Oh, students first. I was going to tell you that, Sue.
First, we do students first. That's the principle.
She was a student at one point.
I know, a long time ago. We'll get back to Mary. We'll give her a chance.
Thank you guys for coming. I wanted to ask about substance abuse issues and how that is sort of dealt with in the context of domestic violence.
Go ahead, Rachel.
I'm happy to take that on. I'm going to quote someone that many of you know, who's Janet Donovan, who was my person who taught me about domestic violence. And one of the things that she told me is that substance abuse and alcohol abuse doesn't make someone perpetrate abuse. It may lower your inhibitions, but if you're not the kind of person to do that, you're not the kind of person to do that. So when we're thinking about issues of substance abuse and alcohol abuse, you want to be really careful and think about how they play into maybe the actions that are occurring, but also not use it to excuse the behavior. And so, for example, to get to your question, in probate and family court, they can do all sorts of testing, but I think the judges really do have a sort of an understanding of how substance abuse and alcohol abuse play a role in domestic violence cases, but also outside domestic violence cases, that just because someone has a substance abuse problem or an alcohol problem doesn't mean if they are being treated for it or they're working towards it, that they shouldn't have the opportunity to see their kids if it's appropriate. So I find that by and large, as long as people are taking proactive steps and admitting what's going on with them, I think the courts are largely sympathetic, as they should be, to people who are trying to rehabilitate themselves.
Another student?
Yes.
Just give Lissy a minute to walk.
Abby's right.
Abby's going to walk.
The second one there. We'll get to you.
Thank you so much for coming, for speaking with us. It's been really great. I worked in family law as a legal assistant prior to coming to law school, and one of the things I found was that it really, it stays with you when you go home, and that, I think, is my biggest barrier to working in family law. So I was curious if you could speak about how you overcome that, and especially with the backgrounds that you all have spoken about, how do you make sure that in doing such important work, you're also protecting yourself?
That's an excellent question. Who wants to handle that one? I'm happy to talk about it too, but.
I'll start. I can get all chime in on this. I've always said, like, for me, it's when I finally left immigration practice, like about 4 years ago, I was like, all right, I'm ready. But it was that survivor stories were actually never the thing that sat with me. It was sort of the inability to access justice through abusive systems that really kind of clinched it for me at the end. But I think along the way that self-care piece is very real. It's very true. It's very hard. We use that word all the time. And I think few of us have mastery around what that means. It is a practice. And it is a day-to-day practice to be able to right size, you're hearing so much trauma, but to lean into those practices that address vicarious trauma, that address how it implicates our own trauma sometimes, is so important. I think remembering to fill your cup, like in the metaphor of like filling your cups, that it's such incredible to work to do this kind of one-on-one work with survivors, and it's so critical to have something else that you can really identify that fills your cup. That it's not that, just the work.
I think for me personally, it's remembering that what happens to somebody else isn't necessarily what happened to me. Even if it's the same exact situation, it's still their story, not mine. It's my role to help them, right? But it's not my role to take on what they're going through. That doesn't mean that I'm not going to be empathetic, sympathetic, compassionate, right? That doesn't mean that I'm not going to speak frankly to them when it's necessary. I had a situation when I was in law school doing clinic work where there was a really bad situation of abuse that I was involved in. And it was very draining to log off. We were meeting over Zoom, and it was very draining to log off and just kind of look around my apartment and be like, whoa. But at the same time, I also told myself, if it's not me, it's going to be somebody else. And this sounds egotistical, but I want it to be me. I want to be the person that helps them, right? So I'm going to go and take a walk after I log off. I'm going to reach out to a trusted friend, family member, mentor, anybody, and just say, hey, I need a couple of minutes. Can I just tell you about some heaviness that I'm carrying around, right? And for me, lastly, therapy really, really helped. It was the best thing I ever did for myself. It's the reason why I can do this work.
Let me also echo therapy. The other thing I can say is it was also great for me for weight loss because I became an avid hiker because I wanted something so different from what I did, and I found each time I sweat, I was like it was really therapeutic, and maybe that's too visual, but it was great. Having a close-knit group of friends helps. Also, having a wonderful family helps. I know a lot of the people in this work tend to have very strong relationships. And I find that really interesting given the work we do. And I will tell you, after coming home from work and hearing these kind of stories and your significant other has not done the laundry, you could care less. And it's I find it's actually a really good way of keeping real what's real.
Yeah, I guess everything everyone said, but also I think that for me, like all of my clients are traumatized, basically, as the pro bono partner, every single, whether they're domestic violence survivors, human trafficking survivors, clients that are about to be deported and they could die if they go home. Like all those things are really traumatic and the stories are traumatic, but I find, in addition to what everyone said, like doing individual representation is so important and you become so invested in your client. But I think doing systemic work is really helpful to that because then you're channeling what you've learned into trying to change laws or advocate for other things with other people who are dealing with the same clients. I think that's also been really helpful. I think when I found that when I was working at Victim Rights Law Center and only hearing client stories all day, it became very draining. But when I was doing it half-time and the other half of the time I was doing trainings or I was doing advocacy work, it became a much better balanced life, you know what I mean? So, I think there's another. Oh, okay. I think there's one other student question.
We'll come back to this.
Okay.
Well, thank you everybody for being here. This is such a good panel, and I'm curious about the abusive litigation because I run our immigration clinic, and so what I'm thinking of is like the standards of a motion to reopen and how the immigration court or the Board of Immigration Appeals acts as the gatekeeper and doesn't bring anybody in for any type of factual hearing unless they think that this, these facts, if we assume them as true, are sufficient to show new circumstances to change the outcome below, blah, 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 blah. It couldn't have been discovered before. All of those standards for a motion to reopen, that it's sort of like, and that doesn't require anybody to come back in, and it doesn't, so I'm just like why? How can this not just be like something like summary judgment that you look at on the briefing and just say, are these facts even sufficient to show a change of circumstances?
I'm happy to answer that question. It's not a satisfying answer, which is resources. The probate and family court hears over 60 motions a day. They don't have they're writing decisions on the weekends. They don't have, there's no resources for that kind of internal, vetting to occur. Same thing with the district court. I don't know if there were resources, whether they feel it was appropriate or whether it curtailed someone's civil legal right to do, but I ask myself that question constantly. Why can't there be some kind of internal vetting or someone look at it? And the answer is always we can't. We just don't have the ability. I think the way resources are allocated in the Commonwealth towards the busiest courts is sometimes, really difficult for people to get the individualized attention to their cases they need.
Yeah, I'll just add, that is precisely what this pending legislation seeks to do. So it's H 1399 in its act regarding controlling and abusive litigation. And what it would do is essentially create just that, a set of criteria. If there has been a prior history of domestic violence or abuse prior, and there's a kind of a establishing of showing, there's just some additional scrutiny on that new filing, right? It's done in a way that really resists, and this is now become law in a couple different states that does the balancing test of ensuring that the courts are not closed off, obviously, and there's no kind of overly strict burden on someone being able to access courts, and yet there is that level of scrutiny that is in place that is more accessible, honestly, to pro se litigants too, so many of whom are in probate and family court. Because currently, one of the arguments against it is, well, those that already exist, right? There can be some, those tools exist, and the reality is those tools aren't applied. They're just not utilized, and there's a presumption of hearing or not. So.
It's a great analogy though too, because I think to the extent you get
Motions
resistance,
to reopen are so hard.
What's that?
Motions to reopen are so
I know,
hard.
that's what I'm saying, it's a great piece of fodder for if someone objects to doing it, the immigration court's swamped, if they can do it,
Yeah.
they make it very
Sit
difficult.
on it forever
So,
and then finally
yeah.
decide it after
Right.
8
Right.
months.
If you're looking at immigration laws, your mom.
that's not really, I can't believe that just came out of my mouth, but it's a good point.
Surprised to hear Mary say that.
I know.
Question over there.
Sorry. Hi. Thank you all for being here. I apologize if my question is too similar to her question, but kind of on the flip side, do you guys ever experience compassion fatigue? And if so, just doing this for so many years, and if so, how do you handle that?
I'm a baby, so it's never happened to me.
I would say know your triggers, and let me start by saying I used to be able to watch the news, especially at 11 o'clock. I can't do it anymore. And at first, I was mad at myself because I felt like I was letting society down, like I wasn't watching the news. And then I gave myself a little bit of my own compassion. And that enables me to have the more compassion I have for myself. I also have trouble, and this sounds crazy, I don't like talking on the phone, because when I first started practicing, no one used email. So I would come into work and I would have about 50 calls from all my clients talking, especially Monday morning, talking about all the things that happened. and I sort of say to myself, okay, friends, I love you all, but I can't do this. So one of the things is when you do this work, you'll notice you have some weird quirks. I mean, otherwise I'm a totally normal person. But some of my quirks are based in this work, and forgiving yourself for them and being able to hold yourself to a little bit less of a standard that you might because of the work you do is a first step in giving yourself compassion so you can show it to your clients, so you stop feeling like, oh my God, it's another call from ex-clients. And, also making sure that you are open and honest and calling out the elephant in the room with the client. I will say to a client, I've noticed you're calling me every day. I can't do this. You shouldn't do this. What's going on? And I feel like if you call out things like that with clients, it helps with the compassion fatigue because you think you know the answer. It's like an argument with your significant other. You're confident you know what they're going to say, but you don't. And sometimes an answer comes and you're like, oh, that's all you needed? You needed a once-a-week email from me telling you what the status is of the case? Oh, I can do that in so much less time than talking to you every day. So I would say know your triggers and ask questions of what's going on when you're feeling particularly irritated at a particular client.
We have time for one or two more quick questions, anybody? Well, if not,
If we can just follow up, I was thinking about the problem of the intersection between the federal law and the state law, and I'm sure you're all familiar with it, but the federal immigration law says that if a person violates a restraining order, they can be deported for that. That always struck me as a classic example of the misguided attempts by Congress to address this issue. Have you seen any evolution of thinking about that? I'm curious in the courts how you confront that, because it always struck me as a deep problem.
So I'm going to take this first.
I mean, evolution of thinking in terms of actually finding a violation, or or
finding ways to accommodate both interests without triggering the deportation.
I think that to me, this really kind of brings us into this larger conversation around these restorative practices and emerging pieces, because I think a huge reason that immigrant survivors sometimes don't report violations is precisely because of those concerns, and wanting to both balance that safety of what a protection order was intended to do, with also feeling for and recognizing the larger consequences both for themselves and the person who caused them harm if they are deported, right? If that individual is deported. So, I mean, I think I haven't been into an IA practice in that context in a bit, so I don't know what you see, Rachel, if that has come up for you in terms of ways of balancing those particular violations, but...
Well, I think there's, I'm sure you know this, there's a colloquy that the judge does with criminal defendants when they plead out to something that makes sure, to the judge's ability, that the person pleading out understands that there are immigration consequences to anything that they plead out to. In terms of, the immigration piece, I'm really torn on it because there are a lot of survivors who won't come forward because they don't want deportation. On the other hand, it is one of the few ways to get someone out of a survivor's life who's torturing them. And so, it's so nuanced. So what I'm seeing in practice is that we go through those with survivors. We go through the consequences that could happen and we talk about them. What I will do is I will encourage the victim to talk to a victim witness advocate and express her concerns. Sometimes I'll do it if need be. So, and it depends on the ADA in question, how receptive and the victim witness advocate they are to what the victim wants. But sometimes things like that can be arranged so that there aren't those kind of immigration consequences. But it's hard. It's really hard.
On that note, everyone, I want to say I admire all of you so much. The work you do is so vital and poignant and hard. and you're changing people's lives every day. And on a personal note, I want to say how proud I am to have Rachel and Emily be part of this. Emily is the first Rappaport Fellow ever to be on a panel. And thank you for being willing to share your own journey with us. And Rachel, as you heard, I hired so many years ago when she got her start in doing domestic violence work. And to have you here, it brings me so much joy and pride. So, and to Hema and Sue, thank you for everything you do for everyone. So, thank you all.